Non-contractual representations and promises. It's often the case that when parties negotiate a contract, there are things that are said during the negotiation phase that do not get included in the formal terms of the contract. The general rule is that anything that is said during the negotiation phase that does not get included as a term of the contract will not be enforceable by either of the parties. This is particularly the case when the contract is set down in writing and signed by the parties. Anything that is said verbally at the time the contract is being negotiated or signed, but that is not included in the written contract and is in fact inconsistent with the terms of the written contract, will not be enforceable. According to the Parol evidence rule, in the event of an inconsistency between a written term of an apparently complete contract and a verbal representation or promise, the court will favor the written term and disregard the verbal representation or promise. This means that when you are in the process of signing a written contract and something is said to you by the other party that is inconsistent with the terms of the written contract that they would like you to believe and rely upon, you should insist that the written contract be changed. For example, if you are negotiating a new mobile phone contract and upon reading the written terms of the contract you notice that there are certain terms regarding penalties that you do not agree with, and the salesperson reassures you that those penalty provisions will not actually be enforced, you cannot rely upon that verbal representation, because if the penalties are imposed upon you and the matter were to go to court, the court would say, well, we are going to go with whatever's set out in the written contract and we're not going to give any weight to what was said to you verbally at the time. So in those circumstances, what you should of course do is insist that the written contract get amended so that the written contract is consistent with what is being said to you verbally at the time the contract is being made. There are circumstances in which a non-contractual representation or promise may still be enforceable, even though it is not officially a term of the contract. We'll consider three circumstances where a non-contractual representation or promise will still be enforceable. First, if the situation amounts to a breach of a collateral contract. Secondly, if the statement and its breach amounts to a misrepresentation. And thirdly, if the false representation or broken promise amounts to a breach of the Australian consumer law. So the first way in which a non-contractual representation or promise can be enforced is by arguing that there is a collateral contract. A collateral contract is a secondary contract. So it's a secondary contract that sits beside the main contract, and the arrangement is that in return for the representation or promise being true and the promise being kept, the other party will enter into the main contract. If the representation turns out to be untrue or the promise is broken, then the other party can sue for breaching the collateral contract. This can be a challenging concept, but it's probably best understood, as usual, by considering the facts of a particular case. So in De La Salle and Guildford from 1901, the owner of a property was negotiating with a tenant for a new lease. The tenant asked the owner of the property if the drains in the property were in order. The tenant had had a bad experience at a previous property where the drains had become blocked, and the subsequent flooding had caused damage to his property. The owner of the property, the landlord, assured the tenant prior to the lease being signed that the drains were indeed in order, so the tenant signed the contract. Now, there was nothing in the written lease that said anything about the drains. Of course, it turned out that the drains were not in order. They were defective, and they eventually became blocked, and again the poor tenant suffered damage to his property. So he sued the landlord for breach of contract. The landlord successfully argued that according to the parole evidence rule, when you've got a written contract, like a written lease, that is what the court should refer to, and there was nothing in the written lease that made any sort of guarantee or promise about the quality of the drains. However, the tenant was able to argue that there were in fact two contracts here. There was the tenancy arrangement itself, but there was a collateral contract as well. The tenant and the landlord had made a collateral deal that in return for the landlord's promise about the drains being true, the tenant would sign the lease. And the landlord had breached that collateral contract, and therefore the tenant was entitled to compensation. The second way in which a non-contractual representation or promise can be enforced is by establishing to the satisfaction of the court that the non-contractual representation or promise is in fact a misrepresentation. So a misrepresentation is a false statement of fact made by one party to induce the other party to enter into a contract, and that in fact induced the other party to enter into the contract. So if the other party has lied in order to get the party to enter into the contract, then the innocent party may be able to establish misrepresentation. If the other party was induced to enter into the contract by misrepresentation, the contract will be voidable. And here, refer back to the tort of deceit that we considered in topic number 4. The third way in which a non-contractual representation or promise may be enforceable is by establishing that it actually amounts to a breach of the Australian consumer law. If the other party was tricked or deceived into entering into a contract, they can commence a legal action using the statutory provisions in the Australian consumer law which prohibit misleading or deceptive conduct, false representations and other unfair practices. And in topic 7 we will be looking very closely at these particular statutory protections.